Thank you.
Good morning. Good morning. This is Judge Keith Long speaking. Before we get started, may I please ask everyone to mute their microphones when they are not speaking. You should see a microphone icon on your video screen which allows you to mute and unmute easily. I am the lead ALJ conducting the hearing today for this case. On this panel and on the video conference, we have Judges Josh Aldrich and Daniel Cho. We are the administrative law judges deciding this appeal. Because of the ongoing concerns pertaining to the coronavirus, the Office of Tax Appeals has decided that it is in the public's best interest to move the Office of Tax Appeals October calendar to video conferenced hearings. We're holding these hearings via video conference with the agreement of both the taxpayers and the agency's agreement. And this change will not impact the fair and objective hearings of the tax appeal. If you are unable to connect or are having technical difficulties, you may call in using the telephone number that was provided earlier. Thank you for your patience and flexibility during this time. This hearing will be live streamed to the public, and the audio of this hearing will be transcribed. As this hearing is being live streamed to the public, please do not show your exhibits on the screen. Additionally, please do not use the chat function within Webex. To minimize confusion during the hearing, we ask that participants mute their microphone when they are not speaking. Please also repeat your name before speaking and avoid talking over others. This is especially important today because appellant is appearing by telephone and may otherwise be unidentifiable. If there are any questions during the process, including any questions regarding the technology, the questions should be directed during this call to me, the lead administrative law judge on this panel. If you become disconnected, please contact Claudia Lopez. We have a couple of administrative matters before we go on the record. The Office of Tax Appeals is an independent and neutral agency. It is not a tax court. All three judges are co-equal decision makers, and we can all ask questions at any time. The hearing will be transcribed, so please identify yourself and speak clearly and slowly. With respect to exhibits, taxpayer has submitted no exhibits, and CDTFA has previously submitted exhibits A through E. At the September 24 pre-hearing conference, there were no objections. Is that correct, Mr. Amas?
Yes, sir.
And CDTFA, can you please confirm that is correct?
This is Randy Suazo. That's correct, Your Honor.
At the pre-hearing conference, appellant stated that no additional evidence will be presented at the hearing. Is that correct, Mr. Amas?
Yes.
And CDTFA, can you please confirm that there are no additional exhibits today?
This is Randy Suazo. No additional exhibits today, Your Honor.
Thank you. Mr. Amas, at the pre-hearing conference, we discussed whether you wanted to be sworn in as a witness. Do you want to present your argument today in the form of testimony as a witness, or do you want to argue based on what is contained in the file?
Based on what is in the file, Your Honor.
This is Judge Long. Thank you. As we discussed at the pre-hearing conference, oral hearing will take approximately 1 hour. This includes 10 minutes for appellant's opening statements, as well as 15 minutes for CDTFA's presentation. At the end, appellant will be given 5 minutes to make a rebuttal. Do we have any questions before we go on the record, Mr. Amas?
No, Your Honor.
And CDTFA, do you have any questions?
This is Randy Suazo. No questions, Your Honor.
And is the reporter ready?
Yes, sir.
We're now going on the record. This is the appeal of Amas, OTA case number 180-83633. It is Wednesday, October 15th, 2020, approximately 10 a.m. This appeal was intended to be heard in Cerritos, California. I am lead administrative law judge Keith Long, and with me today is Judge Josh Aldrich and Judge Daniel Cho. We will be hearing this matter this morning I am the lead ALJ, meaning I will be conducting the proceedings, but my co-panelists and I are equal participants, and we will all be reviewing the evidence, asking questions, and reaching a determination in this case. Before we begin, will the parties please state and spell your names and who you represent for the record? Mr. Amas, we'll begin with you.
My name is Abed I. Amas. And what else, sir? I'm sorry.
Can you please spell your name for the reporter?
A like Apple, B like Bravo, E like Edgar, D like Dog. Middle initial is I. Last name is Alpha Mary Apple Sam, pronounced Amas.
Thank you. And CDTFA?
This is Randy Suazo, hearing representative. RANDYSUAZO.
This is Jason Parker, hearing representative. JASONPARKER.
Sorry about that. This is Christopher Brooks, tax counsel. Spelling is CHRISTOPHER. Last name Brooks, B as in boy, ROOKS as in Sam.
Thank you. CDTFA has submitted exhibits A through E, which are admitted into evidence with no objections. There are no new exhibits. Mr. Amas, we will begin with your opening statement. You have up to 10 minutes and you may begin whenever you're ready.
Okay. Well, I had received a letter from the State Board of Equalization back in November, I believe, at the time where I was not in business. My business had suffered a smoke/fire damage, and I was completely unable to move forward with this matter, since I was inundated with two crucial matters: this matter of the fire in my restaurant, and also the situation with my wife, who came down with breast cancer. I called the CDC, the office, the State Board Board of Equalization, to try to understand what was going on. They presented me with evidence of the tax years that are in question. And, this matter has been going on for the last 5 years, and I really don't know why it took so long. If I had my business going, I probably would have made some sort of a settlement or an agreement to be able to make payments, but I was not able to do so because I had no income, and I wasn't able to be employed until 2018. While the case was going on, I tried to reach some sort of an understanding of how I can move forward with this matter. At some point, I was in a phone conversation with a state board representative from, I believe, in Los Angeles, where and I did not see this on the records, in the exhibits between me and the State Board of Equalization, where there was an amount that they wanted me to settle with, and they wanted me to come down with to make a payment of $25,000 and make payments for the rest of the agreed amount. I believe it was somewhere around $40,000 or $45,000, if I remember correctly. And I was not able to come up with this money because I was not working and I was dealing with issues, personal issues. And up to this date, I was not able to open a restaurant or go back to an income where I could at least make a payment, just like you make payments monthly for other matters like rent and other expenses. So this matter dragged on, and I feel like I should have probably made some sort of arrangements to remedy this matter, and I couldn't. I could not. So here we are right now at this important day for me to be able to come to a resolution of this of these monies. And while it's accruing interest, it has become a big amount that is frankly very difficult to solve. So I am caught between a rock and a hard place. Basically, still unemployed, working here and there, and try to make ends meet. So I'm asking the OTA to be able to make on my behalf to make an appeal to the State Board of Equalization to come up with some sort of a payment plan to get this burden off my back and move forward with it. Like I said, had I been involved still in the restaurant, and the restaurant did not suffer the distress that it went, the restaurant closed. I wasn't able to go back to it, and 5 years from now, my status hasn't changed. So like I said, I'm asking again the Office of Tax Appeal to be able to try to take this matter into consideration and try to come up with a solution for this. And that's all I have to say. I kept saying this for the last 4 or 5 years whenever I spoke with a representative or an officer of either the OTA or the State Board of Equalization, but to no avail. So the matter needed to move forward, and here we are today. That's all I have to say. Hello?
Thank you, Mr. Amos. This is Judge Long again. To confirm, this hearing is for whether for tax disputes. Did you dispute that the tax was owed?
No, I did not. The only thing that I kept mentioning to everybody that I was in contact with, that I wasn't able to provide any documents or any receipts because everything was gone in my restaurant, and I did not have any evidence to prove otherwise. And the State Board of Equalization had presented the case, showed all the receipts, and I am in a situation where I'm not able to provide anything else.
This is Judge Long. With respect to the tax that's owed, we're not able as an agency, the Office of Tax Appeals is not able as an agency to discuss settlement or payment plans with you. However, you are able to contact the CDTFA regarding settlement if that's what you'd like to do.
Could you repeat that?
Yes. This is Judge Long. We, as an agency, the Office of Tax Appeals, is not able to settle or accept a payment plan from you. However, you can contact the CDTFA if that is the route that you'd like to pursue.
And what's the mechanism of contacting them? In other words, what's the next step?
Next steps would be to contact CDTFA. You can find their contact information on their website, I believe. But CDTFA, can you please provide further information to Mr. Amos regarding how he can contact settlement or obtain a payment plan?
I believe, this is Randy Suazo, I believe he was trying to go into offers and compromise.
Yes, at
during
some point.
during the decision, when they had the appeals hearing, he was given the phone number to contact offers and compromise to work out the issue and payment plan.
And I did, and we haven't moved forward beyond that, beyond the phone call.
This is Jason Parker. Yeah, as far as offers and compromise, it's typically for a final tax liability, which this is not a final tax liability because there's a petition for redetermination. So once this goes final, then the offers and compromise can be discussed. And same with the payment plan, that those are for final liabilities that they can enter into a payment plan at that point. To me, it sounded like he attempted to go through settlement before, but did not come to a settlement agreement. And those are confidential, so we do not have access to those ourselves. The settlement program itself is confidential.
And could CDTFA please provide some contact information now for the taxpayer to call after this proceeding is over?
Yeah, so the taxpayer can contact myself, Jason Parker, and I will get him in contact with settlement and offers in compromise. My phone number is 916-309-5201.
Thank you. Now, Mr. Amos, although you've indicated that you'd like to contact CDTFA for a payment plan, I will note that the Office of Tax Appeals will examine the merits of this case and issue our opinion on it after we consider all of the evidence. We're not going to interpret your request for settlement as a concession. We're going to take independent view of the disputed tax on the merits and issue an opinion based on the merits. Is that all right with you, Mr. Amos?
Yes, sir. Yes, Your Honor. I understand. It's okay. I also would like to be able to have the right phone numbers and a contact from the State Board of Equalization to be able to contact the gentleman. I haven't written the phone number down. I'm sitting down outside to have a quiet moment here for this matter. So I need this number one more time, and if it can be emailed to me, that's great.
Mr. Amos, we'll send that to you after the hearing. Thank you. Before we go forward, I want to turn this proceeding over to my fellow judges for any questions they may have to for you, Mr. Amos. We'll start with Judge Cho. Judge Cho, do you have any questions?
This is Judge Cho. I have no question. Thank you.
Judge Aldrich, do you have any questions?
Yeah, I was just wondering, what kind of POS system did you have in place during the audit period, Mr. Amos?
What kind of, I'm sorry, what's the question again?
Point of sale system. So like a cash register or like what kind of software, if any?
Oh, I had a POS system that I was using at the restaurant that was the software that I used called Microfocus that I included in my in the restaurant operation, and there was no other other POS systems from out in the market that I used. I used my own POS system, and that POS system was I mean the hardware and everything was damaged during the fire.
And it didn't have any cloud storage or offsite storage?
No, not at all.
Okay. And do you have any evidence of that there was a fire? I don't know that it was disputed that there was a fire because I saw it mentioned in the audit work papers, but was there an insurance claim or
the insurance claim? We went through it. It took about, yes, there was an insurance claim. And I was also trying to appease the situation then by trying to sell whatever I could have salvaged. But then, I was in a dispute with the landlord, and I had only 6 months left on the second 10-year lease that I had at the restaurant, and I wasn't able to go back and fix the restaurant and go back to it. So it was a done deal.
And it looked like you had bank records available, but you didn't provide them. Is that correct?
I am not sure that I'm not sure it was the right way to say that I don't have bank records. I had bank records, and the bank records are, of course, they're online. I get my bank statements monthly, and I was just basically in a situation where lost my business. Dealing with my wife's malady. She had breast cancer, and I wasn't able to focus for at least a year or more throughout 2016 and partial of 2017. To answer your question, yes, I did get a little bit of money from the insurance, and I had to pay all the outstanding rent and expenses that were accumulating. So I was left with pretty much nothing.
Okay, I guess I'm not understanding if you had electronic access to these bank statements, why those weren't provided to the auditor, if in fact they were not.
I really don't know what was the dynamic of not providing those records to the State Board of Equalization. There was no reason for me not to provide them. I really don't know, Your Honor, why. I mean, there was no direct instructions, because all the 1099 that was provided with the credit card sales and was at the hands of the State Board of Equalization. So the records pretty much that they had are the same ones that showed in the 1099, and all the monies that were coming through the 1099, through the credit card company were correct, and they were in the as an exhibit in the what's the word that I'm trying to use?
The audit work papers.
Yeah, the work papers. They were with the State Board of Equalization. So I really did not know. I was in a very confusing state of mind then. I tried one time to settle the case. They asked me for a lot of money which I didn't have. I don't think I remember I even got any payment from the insurance company until they finished their investigation. So.
Okay. Thank you, Mr. Amas. I'm going to return it back to Judge Long.
Thank you, sir. Thank you, Your Honor.
This is Judge Long. Mr. Amas, I do have a few questions for you as well. So to confirm, after the fire, the business never reopened?
Never reopened. After November 4th, 2015, I did not have single income.
And this is Judge Long. If you never reopened, can you explain why the seller's permit remained open? Why you never contacted BOE to close your seller's permit?
Again, I was under the impression that when I told the State Board of Equalization that I don't have a business anymore, I think the ABC license was canceled. I figured that the State Board of Equalization, the seller's permit, would be canceled as well. I was not, like I said, Judge Long, Your Honor, I was not in a frame of mind to really follow the procedure and do the right thing as far as closing my seller's permit and all that. So I'm sure that it was still open because in my mind the seller's permit was still quote unquote valid, is because we're in the process of an audit. That's why I didn't know whether I should close and call them, contact them to rescind the seller's permit.
Thank you. This is Judge Long. I also have a question regarding the audit itself for you. I understand that you didn't have any books and records. For 2 of the years, the taxable measure is based on the difference between what you reported on your California income tax return and what you reported on your sales and use tax returns for those periods for 2013 and 2014. Can you explain the difference? The differences between those two? Was someone else preparing the returns for you? Different people did they have
that was
access to your books and records at the time?
My accountant was, excuse me, sorry to interrupt you. I'm really sorry. Go ahead.
It's okay. I was done. Go ahead.
I was basically had an accountant that was doing my books. You know, we filed our federal and state taxes, and on a quarterly basis, we were filing our state taxes, and that's what he was sending me, and that's what I was paying. I basically left it up to him. I wasn't too much involved with numbers and stuff. He's been representing me or working with me for many years, and that was the situation. Had I known that there was any discrepancy, I definitely would have taken care of it. I wasn't 100% aware of what he was doing.
Thank you. I have no further questions, so we are going to pass this off to CDTFA to give their presentation. CDTFA, you have 15 minutes. You may begin whenever you're ready.
So this is Randy Suazo. The appellant was a sole proprietorship and operated a sit-down restaurant in San Francisco, serving Middle Eastern food, beverages, and beer and wine. Seller's permit began on November 1st, 1996, and was closed out effective December 2017.
This is Judge Cho. Mr. Suazo, just to interrupt, I think the court reporter had a question for you.
Yeah, I couldn't understand what you said about serving beer and wine.
I'll start over. Again, this is Randy Suazo. The appellant was a sole proprietorship and operated a sit-down restaurant in San Francisco, serving Middle Eastern style food, beverages, and beer and wine. The seller's permit began on November 1st, 1996, and was closed out effective December 2017. This is the appellant's first audit. November 2015, prior to the audit.
Mr. Suazo, I'm sorry to interrupt. This is Judge Long. I'm getting some feedback that we would like you to speak a little bit louder, please.
Okay. Did you want me to start over or where I left off?
Could the court reporter wave your hand if you want him to start over?
I'm fine.
Okay, don't start over. Just talk louder from where you left off.
This is the appellant's first audit. In November 2015, prior to the audit, appellant's business suffered a fire and closed the restaurant. The restaurant never reopened after the fire. The audit period is from January 1st, 2013 through December 31st, 2015. During the audit period, the restaurant was open 6 days a week, from Tuesday through Friday, 5 p.m. to 10 p.m. Saturday, from 9:30 a.m. to 3:30 p.m., and then again from 5 p.m. to 10 p.m. On Sunday, from 9:30 a.m. to 3:30 p.m., and then again from 5 p.m. to 9 p.m. The business was closed on Mondays. The appellant stated that all records were lost in the fire. The department obtained state income tax returns for 2013 and 2014 from the Franchise Tax Board and 1099-Ks for the 2013 and 2014 periods. Since the restaurant was closed during the audit, no site test could be conducted. Because the fire destroyed the appellant's records, a review of gas checks or cash register tapes could not be performed. No markup of menu items using purchase invoices could be done either. Review of transcripts of the sales and use tax returns for the audit period showed that the appellant had reported all sales as taxable and had taken a sales tax included deduction, Exhibit D, pages 26 and 27. The state income tax returns were scheduled and compared to reported sales. A difference of $221,000 for 2013 and $214,000 for 2014 was disclosed. The state income tax record showed more than twice as much in sales as was reported to the department for each year. Exhibit D, page 34. A markup analysis using cost of goods sold for the income tax returns to reported sales disclosed a negative markup of 4.5% for both years. Exhibit D, page 33. The industry average markup on cost of goods sold for a restaurant of this nature is typically 200%. Review of 1099-K data for 2013 and 2014 was conducted and disclosed ex-tax differences of over $165,000 for 2013 and over $150,000 for 2014. Exhibit D, page 32. The 1099-K analysis did not account for cash sales, which would increase the differences. Using the Franchise Tax Board income tax returns, ex-tax sales amounts for 2013 and 2014 were compared to reported ex-tax sales, and percentages of errors were computed. The percentage of error for 2013 was 118%, and for 2014, the percentage of error was 113%. The average percentage of error for both periods was 116%. The percentage of errors were applied to the reported sales for each applicable period. For 2015, the average percentage of error was applied. The unreported taxable sales totaled $622,824. Exhibit D, pages 29 and 30. To review for reasonableness, a cost of goods sold markup was computed based on income tax returns for both 2013 and 2014. The computed markups per income tax returns were 107.91% for 2013 and 103.79% for 2014. The overall markup was 105.84%, which is considered quite low. Exhibit D, page 31. Based on this analysis, the assessment developed in the audit is very conservative. The appellant has not provided any documentation to support a reduction of the liability. This concludes my presentation. I'm available to answer any questions you may have.
Thank you. This is Judge Long. At this time, I'd like to ask if my panel has any questions. Judge Cho, do you have any questions?
This is Judge Cho. I just have one really quick question. With respect to the 1099-K information and your Schedule 12C, I believe, I just wanted to confirm, but that's just the amounts reported on the 1099-K, right? The department did not do a credit card to cash sales ratio and then get an updated figure. Is that correct?
Yes, Your Honor, it's just a 1099-K, so cash would not be included. Bank statements were not available.
This is Jason Parker. I just wanted to add on real quick that because of the fire, we were not able to do an observation test to try to calculate the total sales from credit card receipts. So we only had credit card receipts, and those were the differences just from the credit card receipts.
This is Judge Cho. Thank you very much. That's the only question that I had.
Judge Aldrich, this is Judge Long. Judge Aldrich, do you have any questions?
This is Judge Aldrich. I don't have any questions. Thank you.
This is Judge Long. I just have a few questions. Regarding the fire, which is mentioned in the report of field audit, Exhibit D, page 11, if the business never reopened and the fire occurred on November 5th, why was there no consideration made for this in the audited taxable sales? Can you explain?
When they did the percentage of error, they compared it to what he reported for that fourth quarter. So whatever he happened to report for the fourth quarter, the percentage of error, which was based on 2013 and 14, which were combined, were applied to it. So if he would have reported a lesser amount, it would have reflected on there.
Okay, thank you. And then I also, and that is my only question. So we will move on to closing arguments. Mr. Amos, you have 5 minutes to make a rebuttal. You may begin whenever you're ready.
Oh, I don't have anything else to say, Your Honor.
This is Judge Long. Thank you, Mr. Amos. Does the panel have any questions? Judge Cho?
This is Judge Cho. I have no question. Thank you.
This is Judge Long. Judge Aldrich, do you have any questions?
This is Judge Aldrich. I don't have any questions. Thank you.
This is Judge Long. Thank you. Mr. Amos, we now have the information that you provided today. Is there anything else you've prepared or anything else you would like to tell us before we conclude the case?
No, Your Honor. Thank you for your time.
This concludes the hearing. The judges will meet and decide the case based on the documents and testimony presented and admitted as evidence today. We'll send both parties our written decision no later than 100 days from today. Thank you for your participation. The case is now submitted and the record is closed. This hearing is now adjourned. Thank you.